Sumit Chandar, how do you think it would be interpreted? Because the videography is taking place under the purview of the law and it should be abided by because it's come in the letter of law. Then what? Because the women in question want access to the mosque.
See, Preeti, one thing let us first understand is how a local commissioner is appointed. He is appointed by the powers given under Section 75 of the Code of Civil Procedure, and Order 26, Rule 9 of the Code of Civil Procedure makes it very clear that a commissioner can be appointed to enable the court better appreciate the evidence. Now, judge cannot go anywhere, and that is the purpose. It appoints a commissioner so that the commissioner goes on behalf of the court and whatever the evidence it is, it records it or makes a record of it and brings it back before the court. So nothing wrong about that being happening.
Yes.
Now in this case, I understand that.
Okay. So Shahzad, yes.
Sorry, I'll just conclude.
Go ahead. Make your point, Mr. Chandar.
In this case, what I understand has happened is earlier a commissioner was appointed. Objections were raised to the appointment of that commissioner. The court, as directed under the Kondru Sheshta case of 2006, it was very clear that the court has the power to appoint a second commissioner as well for the same purpose, which has been done now in this case. So nothing wrong in terms of law that is happening here.
Exactly. So nothing wrong in terms of law what is happening here. Shahzad Poonawala, I'll bring you back in this debate if you'd may. And so the evidence is going to be collected through videography. Then what? What does one do with that evidence, Shahzad?
I am in no position to answer that question on behalf of the Honorable Court. The court will decide what it needs to do. As far as I can understand it, let me give you a simple example. A claims something belongs to him. B claims the same thing belongs to him. Today the court is saying, मैं ना A की सुनूंगा ना B की सुनूंगा. DNA test करवाते देखते किसका बच्चा है. So that process is happening. So why are we opposing the DNA test? Those who are opposing the DNA test are actually showing कि उनकी दाढ़ी में बड़ा तिनका है. And let me make one more point very humbly. Look, this is a question of rule of law. Somebody went to court, court passed an order, everyone should follow it. There are people when court passes orders on triple talaq, they don't follow it. So it's actually some people, you may find their PIL rubbish, but they went to court. That is the way to pursue a matter. And then there are some people who think they are secular, they go and oppose what court says, and then they come and preach about PILs being farji and fake and bullshit. But that's not the point. The point is who's following rule of law and who's following rule of Sharia.
Preeti ji,
no, the rule of law needs to be followed here. Videography. I'll come to you, sir. Give me a minute. Mr. Abbas, give me a minute. The rule of law will be followed here. There is a directive given by the Sessions Court and it needs to be followed. But Shahzad, you know, you talk about कि DNA होना चाहिए, बच्चा किसका है. But as per our law in 1991, बच्चा जिसका भी है वो गोद उसको दिया जा चुका है. So that's the point. So where does the BJP stand on this? Because yes, they welcome the videography and it should be done. What from there on? Because these women want access. Then what?
Preeti,
should they be given access? Right.
Before 1990, before the entire Ram Janmabhoomi Andolan took place and then there was a situation in Uttar Pradesh and Ayodhya, this Dainik Darshan and Anushthan used to happen every day. That's the right these petitioners are seeking. So it is a right they had before, even under this act, and it's a right they can continue to have. That is all that is being discussed. But iske aage kya? How can I tell you? The court will decide, and if there's nothing to hide, why are these so-called people so opposed to the court order? Why are they trying to fearmonger in this? अगर facts आपके साथ है, सत्य आपके साथ है, आपको छिपाना नहीं चाहिए, सर्वे करा देना चाहिए.
Okay.
Yeah. I think Preeti, it's a lot more.
Why the apprehension? It's, you know, colloquially common knowledge. Everyone knows in Varanasi that the masjid, which is the Gyanvapi Masjid, has been built on the remains of the Kashi Vishwanath temple. It's common knowledge.
Preeti ji, first and foremost, I don't think the BJP spokesperson understand, and he's trying to make it as a very trivial issue between A and B and the baby. No, sir, it's a lot more complicated here. People's religious worshipping rights are involved. So therefore, I think we need to be a little more sensitive about this matter. Now, Preeti ji, I agree with you on the front that you made the 91, and I'm also of the view that yes, survey must and should be done. From the first day of the debate, I have been saying on the same. The survey must be done. Now the court has ordered from 8 AM to 12 PM. 17th, the report will be out. Along with the advocate commissioner, there will be additional 2 others who will come and let the report come out. And of course, we do have the 1991 Act here. We also do understand the survey taking place. And of course, I think the right way to go ahead is taking this matter with the High Court. And as per the High Court orders, I think both the parties must understand, come into a certain understanding and take it forward.
Well, the good thing is that both parties, especially the mosque administration, at least till now, has not created any objections to it. We did not see any protests, thankfully this time, because the last time around, when the survey took place, it became a communal flashpoint right here in Varanasi. Raghav Avasthi wanted to make a point. Sorry, Mr. Avasthi, we lost you earlier. But I'll come back to the same point. We've spoken about the 1991 Places of Worship Act, but the Ayodhya judgment also, Mr. Avasthi, laid down the law for the future when it said non-retrogression is a foundational feature of the fundamental principle of the Constitution, of which secularism is one.
Let me start with the Places of Worship Act of 1991. So a lot of people on this panel are talking about the Places of Worship Act. However, what we need to keep in mind is that it has a section 4, whereby it says that character of religious places will not be changed. However, there is a proviso to that section itself, which is very clear that it does not apply in case there is a historical or archaeological importance to that place. That is the first thing. The second point that we need to consider is that this is not a public interest litigation. A public interest litigation is by definition something that is filed before either the High Court or the Supreme Court. What is before the court right now, for which this order has been passed under the Code of Civil Procedure, is nothing but a civil suit.
Okay. Sumit Chandra, I'll bring you back into this conversation. The facts that Raghav pointed out on the Places of Worship Act 1991 are rather correct, but also with any place of worship now, you know, once this moves away from the session court, goes to a higher court, Sumit Chandra, will it not go back and be forced to look at the Ayodhya judgment, which in effect has already laid down the law for the future when it says no retrogression?
Preeti, Supreme Court, once of course it has laid down the law, High Court would not be in a position to change it. Obviously, when the matter comes up, it is going to take into consideration whatever the judgment has been passed in the Ayodhya case and the S.R. Bommai case, where the Supreme Court, a 9-judge bench, had clearly mentioned that secularism, and I'll quote Supreme Court here, where they said secularism is the basic feature of the Constitution of India. And that is why it observed that the religion and politics cannot be mixed together. These all aspects have to be considered. Article 25 of the Constitution has to be considered, which says right to freely profess, practice and propagate religion. So these aspects the High Court will consider when the matter comes up before it later in the suit.